Good evening, everyone, and welcome to another edition of my weekly presentation, Legalese. And tonight we have with us as a special guest, attorney Tom DeBari. He is a mediator and arbitrator, and he happens to also be my brother. Now, is your phone on?
I'm sorry?
Your phone on?
No, it's off.
I'm hearing it. Interesting.
Yeah, getting a little bit of an echo, yeah.
But anyway,
All right.
so thank you for tuning in today. And if you like what you hear in the presentation today, please feel free to smash the like button, share, or comment below. I appreciate your comments, your criticisms. I offer this entire segment on your criticism. So that's the problem there.
There you go. You're showing up again.
Yeah, we got to do that.
I haven't been drinking, but I see two of you.
How's that?
There
Better?
you go. Yeah, I think that's better. Yep.
I'm not quite sure because there's two of me below. It's a little bit strange.
There you go. Maybe it's Darren playing tricks. I don't know.
It could be. I'm just trying to see if I can do it.
Yeah, no problem.
I'm going to go off and start this. Well, I don't know that I can really do that at this point in time. Double vision. I know my friend is mentioning that.
Yep, you sound a little garbled too. I don't know if you can hear me okay, but you sound it's a little difficult to hear you.
Yeah, let me go off and start this. I'll go on back in.
Okay.
Okay. All right, folks. I was able to fix that. Thank you very much again for tuning in to this week's edition of Legalese, my legal show where I talk about topics with guests and topics that concern personal injury and litigation and all those important things you need to know about insurance so that you and your families can be protected if the unfortunate thing were to happen, getting involved in an accident or being injured. Today we have as our guest, my special guest, Tom DeBari. He is not just my brother, but he is a preeminent personal injury attorney, and now he is a full-time mediator and arbitrator. And we're going to discuss one particular mode of alternative dispute resolution, arbitration. So, Tom, welcome to the show. Thank you for being here.
Pleasure to be here, Chris. Thanks for inviting me.
Tell us a little bit about yourself.
Oh, yeah, my background, graduate of Stetson College of Law. Prior to that, graduate of Brandeis University. And for about the last 29 years or so, maybe a little bit more, I've been in the field of personal injury, whether it's representing injured people, representing insurance companies and the state and municipalities, whatever the case might be. I've handled all types of injury claims from both sides. So the last probably 13, 14 years of my practice, I've gravitated more toward, as you said, alternative dispute resolution, mediation, and now becoming more fashionable in the state of Florida, arbitration as well. So that is the lion's share of what I do professionally is mediation, and it seems more and more arbitration as well.
Okay, I guess we've become pretty familiar with the idea of mediation. We sort of, mediate in our lives every day in one respect or another. Negotiation is always going on, but arbitration is something different. What is arbitration exactly?
Arbitration, it's one of the modes of dispute resolution. Mediation, to contrast it, mediation is an environment or provides an environment where the parties themselves actually make the decision. They come to the decision, they come to an agreement or not, but it's really their call, and the mediator assists. And arbitration is a little bit different. An arbitrator actually makes the decision for the parties. And there are ramifications to accepting the arbitrator's decision or not. But again, it's a decision made by a third person. And that's the way most of the things get resolved typically in the law is you have a trial by jury. where the jury decides. You have a trial by court where the judge, you have an arbitrator, or an arbitration rather, where an arbitrator or a panel of arbitrators will make that decision. So mediation's kind of on an island out there a little bit, where the parties get to do it themselves. So arbitration, you're entrusting the decision to someone, a member of the Florida Bar typically, and someone who has experience, you would hope, in the field in which the arbitration is being conducted.
Okay, and so how would an arbitration be different from, say, a trial in terms of what's being presented to the arbitrator versus what would be presented to a jury or a judge in the case of a bench trial?
Well, Florida in particular has outlined the kind of the aspirations and the rules for the arbitration. And if you check the Florida Rules of Civil Procedure and the Florida statutes governing arbitration, which I believe is Statute 44, I believe you will see what the courts want. And they want the case presented as simply as possible and with the least amount of testimony and things like that, live testimony. The courts want you to come there with your deposition, testimony kind of in the can, your medical records, and they want you to highlight for the arbitrator the important points of the case. And then a lot of what I do when I arbitrate is get all those records together, the summaries from both sides, all types of records and evidence, assimilate that, digest that, and kind of come up with my award that way. So a lot less is done in the arbitrations that I've handled at the hearing, and more of the legwork is done by the attorneys beforehand and by me afterwards, going in there and sifting through all the evidence and trying to come up with the right conclusion.
So as an arbitrator, what qualifications do you need to have to be able to do this sort of work?
Sure. In Florida, you have to be qualified through the training course, and you have to be a member of the Florida Bar to be an approved arbitrator. I'm certified in state court and in federal court in the Middle District. But the reality is, parties to any dispute, if they want to arbitrate, they can choose essentially anybody to be their arbitrator if that's what they want to do. It doesn't have to be a member of the Florida Bar.
Yeah, isn't it true that you should always read your contracts very carefully, because they may contain clauses that require you to go to arbitration and essentially deny you the possibility of going to court, at least at first?
Yeah, nowadays it's becoming more in vogue that arbitration clauses are pervasive. They're in every consumer contract, just about, whether you're buying a car or a refrigerator or a swimming pool, whatever the case might be. There's probably a clause in there that tells you that you're, in the event there's any dispute arises out of the contract or its performance, it's going to go to arbitration. So yeah, you're right. You have to be very careful. You have to read that. Typically, consumers don't have a whole lot of bargaining power with that. What they're going to do one day. Hopefully, they'll never end up there. But if they end up before me, they'll get a fair decision. Let's put it that way.
Absolutely. Well, are there any rules in the state of Florida that would govern how a case would wind up in arbitration? I mean, these cases are all cases that have been litigated. So like a lawsuit's been filed. How do we get to arbitration under the rules?
Just about any civil case out there is potentially a case for arbitration. And the judges in the various circuits throughout the state, they're vested with a great deal of discretion in managing their docket and referring cases to arbitration. Now, what they typically do is refer, a non-binding arbitration. It's not a binding arbitration, non-binding.
What's the difference between the two?
That's a good question. In a non-binding, you'll go ahead, you'll get your result, you get your award, and then in Florida, you have the option of either accepting the award or appealing it by filing a motion for a trial de novo. In which case, okay, the judge will say, okay, fine, the arbitrator's award is set aside, but I'm going to keep it. I'm going to hold on to it because in the event we try the case and the moving party, moving for the trial de novo, does not meet a certain monetary threshold at the end of the trial, kind of analogous to our proposals for settlement, offer of judgment, then there could be unpleasant financial consequences. That party who did not meet the threshold may very well have to pay attorney's fees and costs, similar to the proposals for settlement.
And Mr. DeBari raises a very interesting issue, ladies and gentlemen, because the proposals for settlements are sort of a formal way that cases can be settled, where one side can make a proposal to the other side, and if these proposals are accepted, then you pick up your ball and you go home. If they lapse or are rejected, then when you go to trial, you have to make a certain number. So when the jury renders a verdict, the verdict will then be set off by any type of collateral source payments of insurance, and you wind up with the judgment. So verdict minus offsets equals judgment, and judgment is the number we're talking about, right? When we talk about whether or not you've made the threshold with regard to arbitration awards and
Correct.
Okay.
The judgment is the enabling document that allows you to collect money or not, or be sought after for the collection of money. So that is the judgment that is key.
So you can literally have a good result, but if you reject it and go to trial, you can win but lose.
Exactly right. Exactly right. You have to not only win, you have to cover the spread, as it were.
Much like a spread in football. That's how I explain it to my clients when I want them to understand proposals and their dynamics. So okay, that's in the case of non-binding arbitration. What about in the case of binding arbitration?
Well, in the case of a binding arbitration, those are typically the ones that the parties enter into by contract, or they can voluntarily submit their dispute to binding arbitration either through the AAA or some other organization, or just a private, arbitrator. So when that happens, the only way you can really set aside, as I'm aware, a binding arbitrated award is by filing a petition with the court having jurisdiction and alleging more or less contract formational defenses like this. We shouldn't have had to arbitrate because the contract was not valid. There was fraud. There was duress in the procurement of the contract or the procurement of the award. Could be, the arbitrator was biased, and we can prove it, and this award should not stand. Those type of things. But the law, especially in Florida, is very much in favor of arbitration awards standing, not being overturned. So there is definitely a presumption that the arbitration award is correct, should be followed, and should be honored. But anything can happen. Certainly, in both binding and non-binding, there are ways to get that award set aside.
Now, when an arbitration is commencing, I mean, how many arbitrators usually will oversee an arbitration? Will it be one or a panel, or how does that work?
Typically, it's either one or a panel of three, when each side picks an arbitrator in that case, and then the two of them get together and kind of select a third arbitrator. That's a popular way as well. In your big construction cases and things like that, perhaps medical malpractice cases, there might be a panel rather than a single arbitrator. But there are advantages and disadvantages, to both. I guess if you're arbitrating on a panel, there's safety in numbers, I suppose. But if you're out there just doing it solo, then there's other advantages and disadvantages to that.
Well, suppose I file a lawsuit in Hillsborough County, and suppose Judge B has the case. He decides that he's going to send you to non-binding arbitration. Now, a judge cannot order binding arbitration, correct?
Correct. Don't order binding because you got your right to a trial. They can order you to non-binding. Yeah.
Now, would you be ordered to arbitration before or after the required mediation?
Typically, I'm getting the referrals in arbitration cases before mediation. That happens as well, but I've seen it both ways. I've seen people mediate and arbitrate, but typically it's arbitration, comes first. And let's put it this way: you can have your arbitration, you can get your arbitration award, and while the time's ticking to file, the motion for trial de novo, you can shoehorn a mediation in there and see if we can't get this thing resolved. This is what the arbitrator said. We don't want to pay it, or we don't want to accept it, but we might be close. We'll get together, and you can kind of have a mediation as well. Or you can move for an extension of time for the motion for trial de novo, have your mediation. So what I'm seeing is in cases that are referred to arbitration, it's the judges are going with the arbitration order.
Have you ever seen arbitrations that take place before a lawsuit's filed?
Yeah, certainly. Yeah. I mean, I typically don't handle those. I handle the ones that are in suit. But yeah, you can certainly do that. You can two people can just let's arbitrate. Let's get an arbitrator before we incur the costs of the suit and all that and all the uncertainty and everything that goes with litigation. Certainly, but if you do that, you're going to be bound.
Now, just because this seems to be what's on everybody's mind nowadays, has the COVID pandemic in any way changed the trend in people arbitrating, not arbitrating? Have there been more arbitrations or fewer arbitrations?
A lot more, in my opinion, and I think there will be a lot more because I believe the judges are going to see this as a way, a legitimate way to move the docket along and to, if not to get the case completely resolved, I think the judges probably say, hey, you know what, this will be a big step towards settlement because the complexion of the case. The parties see this party sees it this way, this party sees it the other way. Now we have neutral third person sees it this way. I think the judges think that's going to impart a bit of a pole star there for continued negotiations, if nothing else.
So you see the trend of arbitration actually something that's going to become bigger and bigger and broader.
I believe it will. I believe.
And I guess right now, given the fact that we're not having a lot of jury trials, then it's particularly useful, even more so maybe than under normal circumstances.
No, I believe it is. It's, anytime you have a chance to get your case resolved, and especially with non-binding, it's kind of optional. You don't have too terribly much to lose with it in that sense.
How is an arbitrator compensated?
We're compensated. Usually there's a per diem in the statute, or you can charge an hourly rate that's within that per diem. And that's typically split by the parties unless it's ordered otherwise, by the court.
Oh, very good.
And I think it's $1,500 a day, is if I am correct about that, is your per diem. But I would defer to the rules of civil procedure and the statutes on that.
Absolutely. All right. Anything else you wanted to say? I've pretty much asked you everything I wanted to.
Not really. I think we covered a lot. The differences between binding, non-binding, the qualifications, the fact that I think arbitration is going to become increasingly more prevalent, and that arbitration can apply to a very wide array of cases, not criminal. Can't really arbitrate criminal, but just about anything else, civil, even domestic. So arbitration seems to be in our lives, whether we like it or not. But if you get a good qualified arbitrator, good parties, attorneys that prepare well, and all my attorneys, they do. I think it's a fair forum for the resolution of a dispute.
There was one last thing to add. Who chooses the arbitrators?
When you get together when you're referred to arbitration, like by panel or for a panel, the parties get to choose. One party will pick an arbitrator. They'll select an arbitrator. The other party will select an arbitrator, and then those two arbitrators have been selected agree on a third one, and they'll select kind of the arbitrator to round it out. And that'll be that might be the difference maker at the end of the day. So it's important. So it's an important selection.
All right, Tom, thank you very much for appearing, and thank you for all that great information. It certainly helps the viewing audience. Arbitration is not something that people deal with, but something they may. And nowadays, it'll be more and more of a probability in case somebody's in litigation. I know there's some judges in Hillsborough now that are ordering non-binding arbitration fairly regularly in cases. So I guess you'll be seeing a lot more of that. And folks, thank you very much for tuning in to the show this evening. And like I said, remember, if you liked what you heard, hit the like button. Please feel free to share and comment below. And I appreciate your questions and your criticisms. Of course, I appreciate your questions more than your criticisms, but I will take them all. Thank you very much, folks. And please listen in for next week's presentation. We're going to have Kat Liddell, who is a dear friend of mine, and going to talk a little bit about insurance. So we'll see you all next week. And once again, Tom, thanks for dropping by.
You got it. My pleasure.
Good evening.
Have a good one.